A petitioner in the Adani-Hindenburg case on Monday filed an affidavit in Supreme Court seeking an, I quote, appropriate order from the apex court. The petitioner has placed on record recommendations by the expert committee. The Supreme Court, remember, is scheduled to hear the case on Tuesday, which is tomorrow. The petitioner, in a new filing to the Supreme Court, defended a 2019 change in rules for reporting by offshore funds, saying that the alteration did not make it tougher to identify ultimate beneficiaries of the offshore funds. The change in rules was cited as one of the factors by a Supreme Court appointed committee that made it difficult for Securities and Exchange Board of India to identify beneficiaries of the offshore funds allegedly investing in companies of the Adani Group. We have that order, or rather petition that's been now filed in the Supreme Court. The court will take up the petition tomorrow. We are discussing those details. Joining us at this point in time is Shriram Subramanian, who is the founder of InGovern Research Services. Also with me in the studio is my colleague Kartik Malhotra. Kartik, I want to understand from you, what are these new developments?
Shweta, so let's look at the timeline and then let's get to these new developments. Now, what happened really was that on the 24th of Jan this year, Hindenburg Research had come out with its report titled How the World's Third Largest Man is Running the Biggest Corporate Con in Corporate History. Now, on 31st of March, Adani Group still decided to go ahead with this 20,000 crore rupee follow-on public offer, the FPO. Thereafter, in the month of March this year, there were these group of petitioners who moved Supreme Court and asked for the inquiry to be set up in this case. Now, the committee was set up. Supreme Court appointed a special committee to look into if there was any regulatory misappropriation or regulatory failure on account of SEBI to have permitted such insider trading or such short selling that Hindenburg had accused Adani Enterprises of. And in the month of May, this committee by the Supreme Court came up and said that prima facie, there was no inclination of any regulatory failure. Now, this was also misreported in many sections of the media as the Supreme Court appointed committee giving a clean chit to Adani and Adani Enterprises. And that was not the case. And in fact, on News9, we were some of perhaps the only ones from the industry who continued to suggest that this report that has come, the prima facie interim report which has come from the committee, does not specifically give a clean chit to Adani Enterprises. Neither does it specifically say that SEBI has not found any reason to believe that that there was no misdoing. And of course, that got misreported in many sections of the media. Now, what has happened today is that SEBI has filed a 41-page report. I haven't got access to that report, but what I'm reading in the papers is that SEBI has filed a 41-page affidavit, in fact, before the Supreme Court. And it has now apparently sought appropriate orders from the Supreme Court to understand how this expert committee and SEBI itself should further continue its investigations. Now, remember, 14th August is when SEBI is supposed to file the result of its investigation or the progress of its investigation in front of the Supreme Court. Now, what has also happened today is one of the petitioners who filed the PIL, advocate Vishal Tiwaris, he has also written a 15-page, filed a 15-page affidavit in the Supreme Court, which is also slated for hearing tomorrow, to really seek expert inputs from the Supreme Court on how SEBI should further go about conducting its investigation. Remember, two basic issues that we are discussing here, and Mr. Subramanian will be able to share more light on that. One issue is pertaining to the 13 companies, offshore companies, on which SEBI has said that it has hit something called opaque structures, which means it is difficult for SEBI to probe and understand at this point who the eventual beneficiaries are from those 13 companies that had taken short positions in Adani Group stocks as suggested by Hindenburg. And the second is, of course, this minimum public shareholding, which is mandated by SEBI to be 25% participation of retail investors. Now, that is also the second issue which is under discussion right now. These are the two primary cases, and in addition to that, the expert committee trying to see if SEBI could have avoided any sort of regulatory failure if at all there was one. That is where we are right now. It is scheduled for hearing in the Supreme Court tomorrow, and I think let's understand from Mr. Subramanian on what really this tantamounts to. Mr. Subramanian.
Good afternoon. Thank you for having me. So this petition by Vishal Tiwaris, who is the original petitioner of the public interest litigation, which basically put onus on the Supreme Court to to constitute this expert committee itself, right? He has again submitted this, and it reads in brief. One of the prayers, or the main prayer here, is to direct us. He is asking the Supreme Court to direct SEBI to investigate all aspects and issues raised by the expert group on the matter of this 13 entities that you are talking about and related to the minimum public shareholding. Both these, while you refer to those two as two different ones, Kartik, they are interrelated, because if those 13 entities are proved to be sort of, the beneficial interests are proved to be somewhere connected to Adani's, then Adani Group would have violated the requirement of the minimum 25%. There is no issue if somebody is owning, some group has a foreign entity owning Indian shares, as long as it is classified as promoter group or it is not classified as public shareholding. The issue really here is that many Adani Group companies have 75% as promoters, 25% as public shareholding, but the allegation is that much of the public shareholding is truly the promoter holding through foreign entities. And these 13 entities could be acting as fronts for the Adani Group. And that is the allegation that needs to be investigated.
Right, Mr. Subramanian, just help us also break this down further. Now, from what I understand, in the affidavit filed by Advocate Vishal Tiwaris today, he says that SEBI has got possibly 3 possible outcomes from its investigation, and one is that it is proved that these 13 opaque structures or these 13 entities have actually received funding from the Adani Group. Second is disproved, and the third is not proved. And right now, it seems to be that the investigation is at the stage of not proved, which means SEBI cannot directly prove nor disprove that the holding of those 13 companies that we are talking about have any of the Adani promoters as benefactors. Is that the right reading of the situation, sir?
One is not clear exactly where it stands. Basically, if even anybody were to outline what are the 3 scenarios that are there, one is proved, the other is not proved, and the third is to be proved, right? So Vishal Tiwaris seems to have outlined the 3 possible outcomes only. 1. 2 is, given the timing of Vishal Tiwaris' petition today, it seems like he is asking Supreme Court to put more pressure on SEBI. In tomorrow's hearing, Supreme Court should put more pressure on SEBI. Of course, the expert committee did refer to timelines, accelerated timelines or quicker resolution or disposal of matters. And this is where I think SEBI is sort of disagreeing. SEBI is saying investigations take time, and especially investigations in outside jurisdictions, because many of these legal entities are abroad. So SEBI needs to ask the Mauritian government, for example, Mauritius, if it is coming to Mauritius or other jurisdictions, to find the ultimate beneficial owner of those legal entities. So to that extent, SEBI's capability and capacity would be challenged in some of these investigations. And SEBI is conveying the same message to the Supreme Court. But the expert group is trying to say that SEBI has to conduct the investigations in a time-bound manner.
But sir, would it be possible in the realm of practicality for SEBI to actually be able to investigate, even if the Supreme Court were to give it directions to go ahead and investigate these 13 possibly offshore entities? Would SEBI have the right ammunition and teeth to go ahead and do these investigations? Or then are we looking at perhaps cross-border agencies to work together, enforcement directorate to come in? What are the next steps from here if Supreme Court were to tell SEBI to go ahead and investigate these 13 entities which seem to have opaque structures?
Yeah, definitely. SEBI has some powers to requisition their counterparts in other jurisdiction. But of course, if SEBI works with somebody like the Enforcement Directorate and other investigating agencies, probably that could hasten the process. One. Two is obviously SEBI needs to reach out to the regulators at other jurisdictions to get to the bottom of the matter.
Okay, and talk to us specifically about the hearing scheduled for tomorrow, sir. To our understanding and our reporting earlier, 14th August was the timeline given by Supreme Court to SEBI. Now, what is this interim hearing slated for tomorrow? Is that to monitor the progress SEBI has made thus far in its investigation, or are we really expecting some real results or some findings from that investigation to come out tomorrow?
I doubt there will be any revelation or findings which will be coming out tomorrow. In fact, what I read in media is that even this 41-page affidavit that SEBI has filed is actually just placing on record the recommendations of the expert committee report and asking for directions from the Supreme Court. So to that extent, SEBI, I think tomorrow's Supreme Court hearing will largely be directions given by the Supreme Court to SEBI on what should be investigated based on the expert committee report.
Okay. And what is this Rule 19 of SCRR that is being referred to in the affidavit filed by Advocate Vishal Tiwaris, sir? It says that if such holding is not public shareholding, the listed Adani companies would have violated Rule 19 of SCRR. Is this the minimum public shareholding only, or are we talking about something else here?
No, this is the same minimum public shareholding because, see, at the end of the day, there is a requirement. This is the securities contract and regulations, right? So basically, that requires a minimum public shareholding of 25%. So if these 13 entities are found to be owned by Adani Group or somewhere related to Adani Group, then obviously, as I told you earlier, Adani, the promoters would own more than 75%. So that is the violation. So in any law, there has to be a violation of some law, right? So this is the violation. The 13 entities being opaque itself is not a violation, right? I mean, you could as well own, if suppose some foreign entity owns 1% of XYZ company, there is no violation by itself, even if it is linked to the promoter. Only the fact is that because here they will violate that minimum public shareholding, that is the breakage of law.
Got it.
Okay. Mr. Subramanian, before we let you go, I want to quickly reiterate, would it be right therefore to say that the expert committee has not in fact given a clean chit to Adani?
Yet?
Yes, that is for sure. I mean, the expert committee has not given a clean chit to the Adani Group. They have never, even in the report, referred to Adani Group specifically. So it was a very, I would say, opaque or a very generic report. And the onus is on SEBI to actually investigate and come out with whatever finality they will have.
And is it also right to say, Mr. Subramanian, thanks for that clarification, and in fact that is completely in line with our reporting on the subject, but is it also fair to say that in its initial probe, the expert committee has not even specifically given a clean chit to SEBI on any regulatory failure?
Yeah, in fact, I would say the expert group is in fact slightly scathing, or at least putting the onus on SEBI to do more work faster. They have definitely pointed out on timeliness of investigations, on other aspects of increased capacity or increased surveillance and investigative capacity, etc. So the expert committee has in fact put more onus on SEBI to pull up its socks.
Okay. So the ball squarely lies in the court of SEBI now when it comes up with its much awaited, much important report. We will keep tracking all those details. Mr. Subramanian, thanks very much for joining, sir, with your inputs on that story.
Thank you.
Thank you, sir.
And with that, it's a wrap on this edition of Business Plus. Thanks very much for watching.